Hi, I'm Joe Tunstall from the law offices of O'Malley Tunstall. We're a personal injury and disability law firm serving the Raleigh area of North Carolina to the coast. Many folks want to know whether they have a case, and that's what I'm going to talk to you a little bit about. If you've been injured due to no fault of your own, you might be wondering whether you have a case. The answer is, it depends. I'm going to talk to you about the factors we consider to determine whether or not you have a strong potential injury case. The first thing is liability. Liability is basically fault. Proving liability that the other person caused the accident and not you is the first and biggest hurdle that we have to overcome. This is especially true in personal injury cases. Insurance companies have no fear whatsoever about rejecting claims, especially in small cases in which there are serious questions as to liability. Put it another way, if the defendant's fault or responsibility is unclear, then so is your chance of achieving a favorable or good outcome in your case. The second thing we have to consider is damages. Even if liability is clear, but there are no damages, then you have no case. Damages are the harm that was done to you, whether you fell or were in a car wreck, including your past and future medical bills, as well as your pain and suffering and out-of-pocket losses. Even in the earliest stages of your case, you probably have some idea as to how severe your injuries really are. Cases involving broken bones, which can be shown on x-rays, are relatively easy to show, but soft tissue cases such as neck and back strain are more difficult because they're not so easily shown on x-rays or MRIs. The third thing we have to look at is ability to pay. Does the potential defendant have the ability to pay? If not, you and your attorney may invest a good amount of time, money, effort, and serious emotional energy in the case, but never see a penny in return. Either some sort of insurance must cover the incident, or the defendant must have personal assets, like real property that can be sold to pay the judgment. The next thing we have to look at is, will the jury really like you? Will jurors empathize with your situation? On the other hand, what kind of person is the defendant? Will the jury like the defendant? There are some bad defendants: the drunk driver, the tire squealer, or the bully. If you have an unlikable defendant, your settlement range may go up. But even more importantly, if the jury doesn't like you or doesn't believe you, your settlement range goes down. Witnesses. Your case is only as good as your evidence. And usually your evidence is only as good as your witnesses. We call them lay witnesses. If, for example, your only witnesses to support your liability is a friend or relative, your case is weaker than if you had several impartial witnesses. Your doctor might be a witness to the medical part of your case. If the doctor involved has never testified, doesn't want to testify, or doesn't do a very good job of testifying, this lowers your case's settlement value. Number 6 is, how tight-fisted is the defense insurance company? As lawyers, we're very familiar with which companies are the most tight-fisted and will make ridiculous lowball offers on cases. So we might need to file suit. However, if the carrier is fair, and some of them are, we might get a higher settlement offer. That's something you need to consider. Next, how much time has passed since the incident that caused your injuries? As a general rule, the longer it takes a case to get to a jury, the less sympathetic the jury will be. This is particularly true if you experience pain or other symptoms for a very limited amount of time after the wreck, but you have fully recovered by the time of trial. How much damage was there to the cars involved? In many automobile cases, the actual damage to the automobile may be minimal, as car bumpers are made to absorb impact. If there was only a bumper scratch or minor fender damage, the jury will question the extent of the impact and therefore the extent of your injuries. On the other hand, if the car in which you were injured looks like an accordion afterwards, it will be easier to convince a jury that you sustained serious and ongoing injuries. To recap, the primary factors determining case strength are: how clear is the defendant's liability? How large and consistent with your injuries are the medical records? Will insurance or defendant's assets fully cover your loss? Will a jury like you and your actions and dislike the defendant and his actions? Do persuasive and unbiased witnesses support your claim? Does the insurer have fair settlement practices here in North Carolina? Will you be fully recovered by the time of trial? And in auto cases, how extensively and visibly was your car damaged? We are available to discuss your situation. You may contact us at 1-800-755-1987.